Hi guys, it's Kathy. I hope you're doing well. Thank you for coming to Wednesday night. I know it's nighttime, but we're streaming anyway. We should be sleeping right now. Sleep is good. We have Christopher Funk today, Judge Funk. You can only see him here. And maybe Court Disorder where I put videos. But just here, no one else gets him. He's from Indiana. And he had a soft sit a couple of months ago that was so good. But now we have a pro se. He handles him, I don't know. Because the pro se gets to say a lot. And I don't know if it's just because the pro se just talks a lot, that maybe some of the things I just end up agreeing with him. Like, hey, wait a second. That sounds right. I don't know. You guys watch and see if you guys feel the same way at the end. Wendy, thank you for 10 months. I appreciate it. Hi, Terry. Monica, Martha, Kelly. Let's see if I forgot it. All right, let's go. Let's get to Indiana, guys, where it's balmy and warm. It's not playing. Of course, it's not playing. Come on, don't do this to me. Try again. Because it's not playing, it's just sitting there spinning. There we go.
Final status hearing for a trial on 126. Morning, Mr. Peppers. Morning.
I'm submitting evidence on the record of the fact that the state hasn't given me a full discovery yet. Those are the warrants for the phone dumps that I've been requesting since May, and then being told that I can't have because they go against the false narrative that's been presented by the state of Indiana. I have yet to have my Franks hearing for the validity of the probable cause affidavit that was filled out in violation of Indiana state law by Matthew Sterling, who admitted in recorded videos that he has a bias and prejudice against my family name, which is a violation of Indiana statute 3533.72. The fact of the matter is he also had a warrant issued in somebody else's name. I would like to enter into evidence my wristband that I'm forced to wear 24 hours a day that clearly states that my name is Robin Peppers. My name is not Robin Kilgore. My name is not Robin Kilgore Peppers. My name is not Robin Dell Kilgore. Those are other family members of which Matthew Sterling falsely claims that he has a vendetta against and has been chasing, quote, back in the day to the Peppers' grandmother's garage, of which is clearly not me since my grandmother died when I was 16 years old and had never had a garage. There is the fact that I still have yet to address the perjury that's been committed by the state of Indiana, no less than 6 times in official misconduct about physical evidence that Matthew Sterling is in videos watching with audio that still has not been presented to me. And there's the matter of the fact that because of the fact that the court hasn't issued any of the things that I've been requesting, that I have filed a verified emergency permanent writ of mandamus with the Indiana Supreme Court for relief. Due to the fact that I have not been served a full discovery as required by Indiana Rule of Criminal Trial Proceeding 2.5 subsections A and B in their entirety, as well as other various Indiana statutes in violation of my constitutional rights. Nor have I been allowed to file any type of police report for the felony theft and felony robbery of my house, of which the state's alleged witness and alleged...
All right, Judge. Jesus Lord, shut him up, Judge. Is there a judge in here? Hold on. Maybe there's a judge in here. Let's see.
Victim admit to in video interviews with Matthew Sterling, who admitted all of this information from his reports before destroying a 9-page medical exam and throwing away 8 pages of it to falsify his probable cause affidavit after the fact. As I said in December, I am not ready for trial because I do not have any of this evidence that is exculpatory in nature that I am required to have under both Constitution and Indiana state law. Until the state provides those documents to me, I am not ready for trial. The fact of the matter is the state knows that the phone dumps contradict their false narrative because I'm being accused of committing a crime at between 1:45 and 1:30 p.m. and video surveillance and text message records clearly show that I wasn't even at the location at those times, which proves that the reports were falsified. I require all of that information, and I am no longer requesting it. I am demanding it because it's my right to have.
So you need a continuance of the trial date?
Yeah, I said that in December. Furthermore, I would also like to bring up the fact that Warden Finn has been apparently communicating with the court and committing perjury, as grievance records with the jail will clearly verify, because I filed multiple grievances about using the legal law library, all of which he ignored. In fact, he's ignored every single grievance that I filed since June of last year. And then he came to this court and he committed perjury about that. He also refused to allow me to attend court for my religious practice. And then he falsified statements to the court stating that I recently converted a Muslim, which is also falsified. It's incorrect because Warden Finn apparently doesn't make documents of any of the grievances that I file about my religious beliefs. And I'm really getting tired of the fact that it seems like a lot of the administration here in St. Joseph County commits felony perjury and felony official misconduct, and it goes unpunished, which forces me to have to file paperwork with the Indiana Supreme Court and the federal Supreme Court in order to get redress.
Okay, so you understand that you still have to follow the rules of the jail in order to access
Unfortunately, the rules of the jail can't interfere with my constitutional rights.
You know, here's the thing, sir, stop. You don't get to do just whatever you want. There are rules, there's procedures that are established. When you come to court, you can't wear stuff. When you go to the law library, it has to be when the staffing is reasonable.
So my problem with that is that I filed multiple grievances about using the law library. I wasn't allowed to do so, and then Warden Finn came here and
do it during business hours.
And then Warden Finn came here and stated that I never requested except for one time. That is a lie. Grievance record clearly show that I requested over a dozen times, and I submitted a filing with this court that had all of the grievance numbers listed, which was ignored completely in December because Warden Finn committed perjury about it. I requested multiple occasions, all of which were during business hours between the hours of 8 a.m. and 5 p.m., and every single one of them was returned to me as invalid request or request refused, while I had an active court order to do so.
Do you have copies of those?
Yeah, he won't give me an actual physical copy of it because he says I have to have a court order to get my grievance records from the jail because of the incriminating evidence against him. Furthermore, me not being allowed to come to court for wearing a kufi is a violation of Indiana's Religious Freedom Restoration Act, which is Indiana state law. I, in fact, have the right in this state to express my religion without restriction. That is Indiana state law, no policy, and it specifically states no policy or administrative ordinance can interfere with that. So, in fact, the jail trying to enforce something that is illegal under Indiana statute is not my problem.
Okay. So as it pertains to 126, you're not ready to go to trial. You're asking for a continuance. How much time do you think you need reasonably?
I need all of the evidence presented to me that's been being denied to me since May, and we can go from there.
Okay. Well, I want to put it on the trial calendar for you so that we have a date. If we just leave it open, I know that you're concerned about getting this done in a timely fashion based on the filings. So I know that I don't want to just leave it hanging out there for forever. If we set it to May 11, does that work for you, sir?
As long as the state of Indiana produces all the evidence.
We're gonna talk about that too, but the date of May 11th, is that okay with you, sir?
Well, like I said, as long as I can have the evidence that the state has been holding back.
Okay.
Because there is video of Matthew Sterling watching the surveillance unit with audio, going through phone records, all of which I
don't need to know about the particularities of the evidence. I just need to know whether or not you can be ready to go to trial. So, state, there's been a lot said, but do you have anything that hasn't been turned over?
You're the only thing that actually brought was and Mr. Peppers had filed some filings regarding this. A search warrant to obtain Mr. Peppers' DNA was submitted and executed earlier, I think late December, early this month. So I just got copies of that, and then the state lab did complete the DNA results and there was a copy of those results. A copy was mailed and I emailed a copy to the jail staff. I did bring a physical copy just in case. And as far as items, I mean, Mr. Peppers has listed quite a few things that I'm not aware of necessarily existing. That's not to say that they're not out there, they're just not maybe in what we have right now.
I'd like the record to show that I'm trying to give the state of Indiana the warrants for the evidence of which they claim that they don't have. And I'd also like to point out that they filed a filing a couple of months ago stating that they haven't actually reviewed any of the evidence that Matthew Sterling has, that they've been taking his word on it when they stated that the indictment wasn't fatally defective because they're accusing me of doing a crime on May 15th, not May 17th.
These are the copies.
All right, so Mr. Mills, this is it?
Yes, that's,
Being mailman.
and so.
The state has proffered those things to the defendant, and the defendant has proffered his items to the state. Mr. Peppers, what you just gave the state, are those your copies that you need back, sir?
No, I have several copies of them.
Okay.
So does the Indiana Supreme Court.
Okay. Great.
And once again, I'd like to point out that this quote unquote warrant is not in my name. It's in a Mr. Kilgore-Peppers, which is not me. That is a different member of my family because Matthew Sterling doesn't know who I am. Once again, in the recorded videos of Matthew Sterling, he claims to have a vendetta against who he refers to as the Peppers clan, and he continuously refers to chasing, quote, me down to my grandmother's garage, of which he's never done. He also claims that he's dealt with me
You gotta
for years.
understand, sir, that the minutia of the evidence on a day like today isn't the thing, right?
Well, that's why I've demanded a Frank's hearing for the past 2 months. And it's just been overlooked and has silence on the record.
Okay, well, then we'll set that hearing for a couple of weeks from now.
What's the date?
On February 4th at 11 o'clock. Actually, we'll move it to 10 o'clock. 10 o'clock on February 4th.
And what kind of hearing is that?
It's a Frank's hearing.
Frank?
Frank's. Beans and Frank's.
Franks and beans.
And then May, what was the second date?
May 11th is your trial date, okay, sir? And then we'll set your record date for April, State, is there any objection to continuing the trial date with January 26th?
There's no objection, Your Honor. However, the state is prepared to go. I did confirm the availability of all of our witnesses, so we were ready to go to trial next week, but because it's defense request, we requested the CR4 would be attributed to the defendant.
Sure.
Well, unfortunately, it can't be because the state has refused to provide this information that I have demanded in writing.
Mr. Peppers, you know what, here's the deal. I'm not.
I mean, you can argue with the Supreme Court.
Stop. I'm not convinced that these things exist. You're telling me that you're not ready.
Oh, you mean besides the videos that I have of them? I mean, if you'd like, we can have the videos brought from the SD cards in of Matthew Sterling watching his videos with audio. I mean, that's perfectly fine. It's on video. It's not like I'm making it up. You guys have it. They know that they have it. They just don't want to acknowledge it because, quote, they're filing. They haven't even looked at it.
Well, the state has been, I don't have any reason at this point in time to believe the state has held back on.
Well, I mean, besides the perjury they committed on May 30th, August 20th, September 3rd. Well, I'm just saying, they've committed perjury about not having my surveillance unit, then they had it, then they needed time to depose it, then they needed more time to depose it, then they deposed it, and they decided that they deposed it back in May, and that it doesn't have audio, even though physical evidence directly contradicts that. That is perjury by definition of the law. So you're right, you don't have any reason to not believe them besides the felony perjury and official misconduct that they've committed on the record. I would also like to know why no one's responded to my request for a certified chronological case summary and record of the proceeding to send to the Indiana Supreme Court for my writ of mandamus as required by Indiana state law that I filed multiple times, had recorded, and have a copy of that was recorded last month. I've been filing that since November and being ignored.
Yeah. The clerks have been directed to comply with requirements there. So we're looking at a trial date, May 11th, record date, perhaps April 8th. That'd be a deadline for filing any motions for the 511 trial, also a deadline for entering a plea agreement.
So that was April what?
8th
Thank you.
or 8th. Right.
And Your Honor, just for clarification, on the DVR that Mr. Peppers has wanted to review,
Right.
that is the item that we were providing in December, and I believe again, I think twice in December.
Twice in December.
And then there was a failed refusal transport. And just for the record, the entirety of that DVR is not included in the state search warrant. So the state has not looked at the entire contents, because I believe
Unclear.
there's.
That would be overly broad.
Yes. And however, it is Mr. Pepper's property, so if Mr. Peppers chooses to examine that in its entirety, then it is likely that the state would request to also have access to that and expand. But at this juncture, we have no reason to request looking beyond what is in the warrant.
Right.
And I do have access to that unit. I've put that in writing many times. And according to all the documents I've been served, nothing that's been seized from my home and place of business is even remotely being considered as evidence, and yet none of it's been returned to me.
Well, I don't know about returning property to somebody who's in custody, but the essence of what we're talking about with that unit is that you were provided an opportunity twice in December to come over and have access to that unit and review whatever you wanted to on there, and you just declined to come over.
I did not decline. I was refused transport by St. Joseph County Jail, as I've stated multiple times.
Understood, but either way, it didn't pan out, and the state was prepared to have that available to you, and the court had prepared a place for you, and all of that. So, and you understand that when the state says that they've looked at that unit, they've looked at what was specified on that search warrant, which is between X date and Y date. They haven't looked at the whole entirety of whatever might happen to be on that unit, because that would have been overbroad, and they respected your constitutional rights. So that's, if you think there's some material on there that is important for your case, but they haven't looked at it, then just know that they wouldn't be aware of that. And if you decide you want to use any of that in your trial, you'll be required to notify the state about what it is and where it is.
Oh, trust me, I know.
Okay.
The point of the matter is that the fact that if they had looked at the surveillance at all, they would know that I wasn't even at the house at the time of the false accusations by Clausetta Chanel.
Okay. Well, that's all good stuff to build your case on that. So we will come back for our Frank's hearing on, did I say 211?
2-4.
2-4, yeah.
And for that, are we going to be, just so we're prepared, does the court want to address all of the warrants, or does
Mr. Peppers, what warrants specifically are we working to address here?
I'm going to address all of them. The fact of the matter is that, like I said, Matthew Sterling failed to disclose in his probable cause affidavit that he has a bias and prejudice against me and my family name as required by Indiana state law. He then filed a affidavit in somebody else's name, claiming that it was me, claiming that he's dealt with this person for years, which Matthew Sterling has never dealt with me, ever. So on and so forth. He then attempted to fabricate probable cause by deleting 8 pages of a 9-page medical exam and selectively picking statements that were made that were contradicted in interviews.
All right, so here's what we're going to do. Before we come to that hearing on 2-4, please file a specific motion to suppress the evidence that you believe it was obtained pursuant to bad warrants, and specify the warrants, okay?
Yep.
So the state can be on notice. And that's set in just a couple of weeks. Can you have that done by Monday, you think, 26th?
As long as I can get in to type it up, yeah.
Okay. Mr. Peppers, these items that you handed to the court today, do you want these back?
No, I have my own copies. That was just to prove that it is fact that the state of Indiana does in fact have the phone dumps that I've been requesting since June.
Okay. For today's purposes, we took note that you can do those papers, but we'll give them back to you so you can use them in the future. All right.
And Your Honor, just for the record, it is the defense's motion, so we're asking that it'll be CR4 to the defense.
Yeah, CR Force Defense. I understand your position on that, Mr. Peppers.
Your Honor,
Sure.
there were some documents in there that he was to view. I told him not to take them at this time because I didn't know what they were. Is he allowed to have those or not?
It's the jury stuff, but if we're vacating that trial.
Yeah, we won't worry about that. It was the jury
Okay.
questionnaires for this trial that was just vacated on the defense motion.
Here's the CCS he was requesting. I printed
Okay.
it.
So on the record, he's been provided a copy of the chronological case summary. All right,
Do you know when I'll get a copy of the certified transcript of the record?
certified transcript of the record.
Yeah, both of those are required for my writ of mandamus.
Certified transcript of the record.
Yeah, the record, the recording, what she's typing over there.
From every hearing?
Yeah.
That's not gonna be ready for quite some time.
Well, as soon as you get it ready for me, let me know, because I need to send it down to the Supreme Court.
Okay.
Off to the Supreme Court of Indiana he goes for 6 counts of felony perjury against the prosecutor. Oh my gosh. Don't worry. We're going to keep following that guy. I wonder if I should start looking at the Supreme Court of Indiana. Let's see if I can get him there. Do you think he's actually going to get a chance to stand in front of the Supreme Court of Indiana? What are his chances really? I don't know. I don't even have a guess. Like, do normal people just get to do that if they keep appealing? Where is Idaho when we need her? All right, guys, we're moving on. I think this is Colorado, right? Is that Colorado's flag? I think this is Colorado. If it's Colorado, yeah, I don't know. Let's just watch it.
Hey.
Good morning, sir.
Good morning.
So, Judge, in speaking with Mr. Snell, he has a few things that he'd like me to look into for him. So I'm going to ask to reset him for Monday.
And that would be,
The
Okay.
26th.
all right. And that's what you'd like to do, Mr. Snell?
Yeah, sure. I'm trying to bond out to get back out to Boulder, smoking cigarettes, playing Nintendo Switch, etc.
Okay.
I was wondering, I actually have a Nintendo Switch. Is there any way to get that in the jail cell?
I doubt it.
Oh, come
Yeah.
on. Come on.
Nice try.
People would probably be trying to take it from you.
That's
Oh,
true.
right.
Yeah.
All right. Then, with respect to these 3 cases, it's CR 2024-4832 GE, CR 2025-1272 GE, and CR 2025-4623 GE. I will set all 3 for next Monday, the 26th of January, 2026, so that your lawyer,
I hope you can hear me. I lost power. So I'm just getting everything back up and running again. I lost power for a tiny second. Just a tiny second it flickered. Sorry guys. It's very cold here. Maybe that's why I lost power for a second. But 14 of you are still here. Everyone else left. It's fine.
with respect to these 3 cases, it's CR 2024-4832 GE, CR 2025-1272 GE, and CR 2025-4623 GE. I will set all 3 for next Monday, the 26th of January, 2026, so that your lawyer, the public defender, has time to look into the matters that you've discussed. There is also, I was trying to look at this behind the scenes between folks, but there is also a bond forfeiture issue. And Dara, is that in all three cases?
Yes, all three cases have bonds.
All right, then, and it looks like, let me just check each case. The FTAs looks like we're on November 13th of 2025.
You can't hear it? It looks like it's fine to me. Refresh. If you can't hear, refresh. If you can't hear me tell you to refresh, I don't know what to tell you.
All right.
All right. So in all three of these cases, sir, and it would be the same case numbers I had read out just a moment ago, you had a court date on November the 4th, and you failed to appear in court as promised when you posted the bond. And those were cash bonds, $50 in each case. You were sent a notice of forfeiture back on the 13th of November, and the court finds that those notices of forfeiture and citations to show cause were sent within the 14-day required time period.
Mm-hmm.
And
I haven't known where to go to court after posting bond because I thought after posting bond it was over, but
no, posting bond is just a promise to appear, and it would have said that on the paperwork that you signed.
mm-hmm.
So at any rate, so the 14-day requirement for the notice to be mailed out was in fact met. The hearing date on the citation for show cause was January 9th of 2026, which is more than 35 days from the date of the notice, which is also one of the requirements. So the court finds that that requirement was met as well. It was also at least 21 days after the service of this citation to show cause. So you did not appear on that January 9th date, and as such, the court is ordering that your bonds in those cases be forfeited. So it's a $50 bond in each case. That money no longer belongs to you because you failed to appear, and then you failed to appear in response to the notice of forfeiture and citation to show cause. So the court will be collecting that. Now, as far as any other bonds that you post, that's a new story. You have a chance to come back to the court anew. And to be clear, when you post the bond, it is not paying money for the case to be over. You need to come back to court, and it'll have that court date in your bond paperwork. It will also have, the things that you're required to do, one of which is, the primary of which is to show up in court when you're supposed to, okay?
See, I don't have a car.
I'm sorry?
I don't have a car, so it's kind of hard for me to get anywhere.
That's something you're going to have to figure out. Plenty of people do it all the time. Like, maybe camp closer to the courthouse at night or something like that.
Mhm.
Well, what if I can't achieve this, because I'm a bum. I don't have that many means to do anything.
Well,
but Mr. Snell, I talked with you about this. If you come to court, we potentially have some resources to help you. That's what we try to do in this court is, when people are having trouble because they're unhoused, we try to get them some resources. That's why it's so important that you come to court, because we might actually be able.
And if you guys have never seen what Colorado does for their unhoused, they are not joking. You just walk up and you get food, clothes, you get your ID. They help you get your ID. They put you on the right path to get your driver's license. If you just walk up and ask for help, they dismiss some cases. Like, oh, you have these cases? Dismissed just because you came. They get you everything, a job. They give you gas vouchers, whatever you need. There's a whole army of people, and they're usually outside the courthouse in the cold, handing out coffee and sandwiches, getting these people medical help and whatever they need. There's an army of people to help them in Colorado. It's insane. But they also have a large amount of homeless people. There's people get arrested every day for having a tent. You're not allowed to put up a tent every day, smoking and having a tent, smoking a cigarette and having a tent, because they're homeless and they're just going in and out of the system every day. But they do have resources, a lot.
To help you if you do.
Can I say something for a moment?
You may.
When I was younger, I was a punk rocker. I was a liberal. I was vastly liberal, and in part conservative. And they have me, like, in my mind, what I'm hearing is they want me to be a Buddhist that's serving as a devil, kind of. Now, that's on the more crazy side, but I'm not going to say anything there. But the thing is that I'm afraid as a punk to bring anything up, because if I say anything, I'll get screwed over by kind of an anti-transient kind of mindset is that. Like, anyone that's radical gets screwed.
Mr. Now, this, of all places you are, this is not an anti-transient mindset. We do everything we can to help folks who are unhoused. And we do have resources at the court, like Ms. Talene just told you about. So please come on over to the courthouse when you're able, even if you don't have a court date. We can talk to you and provide you resources. There's people at the court who do that work full time.
Right. I've gone to the Louisville near Via Appia.
To come to Boulder, because Boulder is the location that has all of the resources. I work for the municipal courts in both Louisville and Lafayette, and they don't have nearly the resources that Boulder does.
Because in Louisville, I went to that place on near Via Appia to get my possessions in Louisville at one point and sum some stuff up after I left jail. And they didn't even,
Come to Sixth and Canyon, okay, Mr. Snell? Sixth and Canyon.
Sixth and Canyon. And if you have further conversation to have with Ms. Talene, I'll leave that between the two of you. But for now, your cases are over. The 3 cases are reset to next Monday, the 26th. And also the bonds that you had posted a few months ago in those cases, the $50 bonds, are all forfeited and no longer belong to you. So that ends the court's interest in these cases today. We'll see you next Monday.
All right, so I should try to get a bond. I should try to get a bond, and then once I leave, then I go to the court thing, and
if you get a bond, it'll be on a different day than next Monday. If you're still in jail, we'll see you Monday.
All right.
Okay. If not, you need to come to court on the date it says on your bond.
Right. That's the thing about the radical thing is radicals are said to speak their mind. I mean, I'm part conservative. I'm like kind of a non-burning libertarian.
To stop you from speaking your mind, but being in court here, it takes up a lot of resources.
Right.
And so the court is finished with this matter. Okay.
We're afraid to say anything, is it?
Nobody's going to get you in trouble for saying anything. We'll see you next week.
Right.
Okay.
Hang on right there, okay?
He's afraid to say anything.
Is that does that conclude our jail docket today?
We have Mr. Parsons still.
Yeah.
Yeah, me too. I'm totally too scared to say anything. I know more about that man's day than I know about my son's day because of how much he talked. Bobby, where are you, Bobby? Okay, now we're going to go to another state.
Fully court, it will show that there was a deed.
Okay. So I left the beginning part in because you want to know why? They're just a normal, crazy court staff talking about the snow that we are all battling right now. And phew, we're supposed to get more snow on Saturday. We just got a lot of snow. So this is, it's just a few minutes long. I left it in so that we can just associate.
I tried to open my garage yesterday and it was frozen. It was like frozen shut. My husband was afraid the garage door was going to break. But luckily we were able to get out because we had to go, my husband had to go plug up his truck because it's got a battery. It's a diesel, so he had to go start it to get it ready in case he had to go to work today, which he didn't have to, thank God. But he was like freaking out because he was like, oh God, I think I'm going to break the garage trying to open it.
Yeah,
Everybody have experience.
Oh, it is freezing. I have a question.
No, don't go to court. Now she's going to talk about court, I think. And we were having such a good conversation about the snow. I think we've all been beat in this chat growing up, Jude. I think all of us were beat growing up. My mom used to beat me before she beat me. Yes, it does. It does not snow enough here for my liking. It just doesn't. This is like the first snowfall of the year. We had a little tiny micro snows before this, but they don't count. They just don't count. I'm at 9 degrees, Kristen. 9 degrees. It feels like a little below. But okay, now they're gonna talk about court. And this okay, I have to tell you this up front so you know. He is not pro se. He's the lawyer. You're gonna think, man, this is a pretty bad pro se. You'd be wrong.
Attorney Harper,
Yes.
your name, it has a cause number of DF23, but I'm seeing DF25.
It's 2-5. I'm sorry.
Okay. No, that's fine.
That was my mistake. I think I just noticed that.
Okay. I wanted to make sure I was on the right case because
You
everybody
are.
else.
I was, yeah, I'm
Yeah,
sorry.
Like is that.
Okay. And good morning, Attorney Franklin. How are you?
Morning, Judge. I'm doing well. How are you doing?
Good.
Need to
All
put my
right.
card
Let's
number.
see.
Like,
All right. So for this case, I have 1, 2, 3, 4. I have 4 exhibits for the husband. And then for respondent wife, I have 2 exhibits. Is that correct?
Yes, she's the respondent in this motion, but she was the petitioner in the original matter.
Okay.
Does the husband have 4?
You have, let me see. 1, 2, 3. Yes, 4. And then,
DC, you're not here, but I'm thinking
all
about
right,
you.
both sides ready to proceed. Does the state have anything?
Judge, we didn't submit anything. We were noticed to be here because we intervened in the divorce, but we didn't file any pleadings or anything.
Okay. All right.
When did you intervene into the divorce? They don't have any children together.
I was about to ask that question.
I didn't see intervention.
you're on the wrong case.
Oh, I'm sorry. This is not the
Oh,
McCormick
Lord
case.
Jesus, you scared me to death.
I
I was thinking to myself, is there something I don't know about? Like, I'm serious.
I don't like it.
Oh,
no,
no, sorry. I thought
I
this is
just-
the McCormick
That's
matter.
okay. Okay, you almost gave me a
No.
heart attack, but that's okay.
No, you, Attorney Franklin, you almost gave all of us a heart attack. I'm like, wait, what?
I think my client the most, right? Because she was like, I had a kid I didn't know about.
I don't like it.
Sorry, y'all. Sorry.
That's okay.
But it was good to see you anyway.
You too, Judge. So that one isn't set this afternoon. I just wanted to make sure.
No,
Okay. So sorry, y'all. We're not being
no problem.
No
Yes, have a
problem.
good rest of the day.
Okay, you too. Y'all stay warm.
Thank you, you too. All right, both sides ready to proceed?
Yes, Your Honor.
Yes.
All right, Joey, you ready?
I'm ready, Judge. Go ahead. Thank
Okay, we're on the record in cause number DF2508117. Councils, will you please announce for the record?
Vincent Ndukwe appearing for the movement, 1 Ariaga.
Danielle Cortez Harper, appearing for the respondent in the motion for new trial, Yolanda Alvarado now. Previously,
All right.
Yolanda Arriaga.
All right, with those who intend to testify, please raise your right hands. Do you all swear or affirm? Oh, I don't see your hands.
I'm sorry. Can you see it right there?
Yes, and Mr. McCormick, raise your right hand.
Is this still the case for Aaron and Yana McCormick?
Oh, yeah, you're not, yeah, no. You can log off with the state. They've already left. I'm sorry.
Oh, okay. So it's been rescheduled or what am I doing?
You know what? That great question. It's not on my docket. It's possible you may be on Judge Lee's docket.
Per the case file, the hearing that they had scheduled today was removed because there was no exhibit conference.
Oh, you all didn't have an exhibit conference. So you're going to email the my coordinator. Do you have her email address?
Is that Brittany?
Yes.
Yes.
Okay. So you're going to email her, and then she's going to get you all reset with a date for an exhibit conference.
Okay. All right.
My
thank you.
apologies.
Okay.
All right.
Don't forget to swear her in.
Okay. Now, ma'am, raise your right hand. Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, I do.
Thank you both. All right. So we're set here for today on a motion for new trial. This was a divorce and a default judgment was granted. And the movement has filed a motion for new trial. Prior to going on the record, you all had an exhibit conference and some exhibits were pre-admitted. They will be admitted at this time. So movements exhibits 1 through 4 are admitted and respondents exhibits 1 through 2 are admitted. Did I get that right, counsels?
Yes, Your Honor.
Attorney
Yes,
Harper?
I'm sorry.
Okay.
Yes.
All right. So I have you all set at 15 minutes aside. That will include any opening and closing statements should you all choose to make one, as well as any examination of your witnesses. Attorney Ndukwe, at this time, would you like to make an opening statement?
Yes, Your Honor.
All right, you may proceed.
Your Honor, may I please the court, my client is incarcerated in Oklahoma. So he's not here now. He's supposed to appear by Zoom, but he called me and told me that the court is closed there, that they won't open until Wednesday. So I have his sister here. Okay. These people, according to their own pleading, they were married in 2015. Okay. And as strange as it might sound, this marriage was when my client was in jail. So my client was locked up in 2012. So the respondent came to the prison and married my client 3 years later, which would be 2015. My client was not released from prison until 2019. And I will tell you why these data are important. Okay. Subsequent to that, my client was arrested again in April 2025. He was arrested in Oklahoma for the charge in Texas, and he was brought back to Oklahoma 2 days later in April of 2025.
In April of 2025, but what's going on with his tie? His collar. I can't watch this whole hearing. I didn't notice that one when I recorded it. And now I'm going to have to turn this off because there's no way I can stare at that for the whole time.
My client was locked up in jail in Texas from April 2025 until September 2025 when he was moved back to Oklahoma.
You know, Attorney Ndukwe, you're going in and out.
Okay. Okay.
Your Honor, I'm going to object to him testifying as to facts. There's no affidavit attached to.
No, I'm giving his body, my general background. I can call your client testify. I got
Okay,
a
but he's
witness
not
here.
there. You just said he's not there.
Counsel, I'm making an opening statement.
Okay.
It's not a
But
testimony.
I'm objecting because you're stating facts that are not supported by an affidavit. A motion for new trial must be supported. If it's going to go outside the record,
No, that's
it must
not
be
true.
supported by an affidavit. That is true.
Okay,
That is
so
true.
you all are not going to argue back and forth and speak over each other. She's making an objection. From what I'm gathering is that you're testifying to facts that are not in evidence. And this is your opening statement. So I'm going
Yes,
to
Your Honor.
sustain her objection and just state what your evidence is going to show.
Okay. My evidence will show that my client was locked up in 2012 and he was released in 2019. And they were married in 2015 in the prison. So, subsequent to that, evidence will show that my client was arrested again in April 2025 and was brought back to Texas. And he wasn't found in Texas until September 2025 when they moved him back to Oklahoma.
Ladies and gentlemen, I hope that you've already learned a lesson, but I'm not going to tell you what it is. But I hope already you have learned a very valuable lesson if you are unmarried right now.
And also evidence, exhibit number 2, we show that this property, one of this property involved, was purchased in 2009, which was years before he married my client. So this is a separate property that was awarded to the respondent. And they will share, they will try to tell you, oh, there was a
I'm gonna object again as to him
I'm making
stating facts that are not into evidence.
Counsel, I hope, Judge, I hope you're not counting my time against me, because I'm telling you what evidence we show.
Okay, so when you're Attorney Ndukwe, I don't know what's going on with your microphone, but it's going in and out. So I'm not even catching everything that you're saying. But just tell me specifically what your evidence, the evidence that you submitted, the deed.
Okay.
The
deed.
Submitted, just tell me what it's going to say.
Exhibit number 2, which is the deed, we show that the property was purchased in 2009, which will be about 7 or 8 years before the marriage. And their own evidence, exhibit number 2, they will try to fool the court. It will show that there was a deed of trust for the same property in 2017. And as I told you, it was notarized. And this is the time period my client was in jail, because he was released in 2019. So our contention was that deed we showed that was signed allegedly in 2017, deed of trust, was forged. It's not my client's signature. He can't notarize something from jail. Okay. Thirdly, exhibit number 1. Judge, you can hear me. Is it still cutting off?
No, I can hear you. I'm just taking notes.
Okay. Exhibit number 2, which is most important of evidence in this case, it will show that that my client was never served. If you look under exhibit 1, 2, 3, 4, like.
Okay. Just to keep you up on what's happening, because it's bull. It is a huge load of bull. But you don't get that far in this hearing. He bought some properties, I think 3, could be 4, all right? No, I can't control the YouTube chat on the screen, okay? I feed the YouTube chat link, the URL, into the software. YouTube decides which chats show up and which ones don't. I can't fix or touch that in any way by live chat or funding or top chat. I have my own chat box beside it. I can see. Wow. Hi, Mike. Welcome. Boy, you just missed a crazy pro se. He is off the deep end crazy. We're going to be in hearings forever. Now, for all of you who are just stepping in to this case, I need you to buckle up first. I just do. The guy you see on the screen is an actual lawyer, not pro se. You're going to think he's pro se. He's an actual lawyer, okay? And what happened is that you missed so far is this guy was incarcerated. Before he was incarcerated, he bought, I believe, 3 properties, 3 houses, or 3 pieces of land, or a mixture of both. Then he went to jail. While he was in jail, he got married. Listen, don't ask me how. He got married while he was in jail, okay? While he was in jail, he got divorced. She took everything, his 3 properties. This is a lawyer trying to fight to get those properties back. And I promise you, he's a real lawyer. I know he looks pro se, but he's not. And all you Raiders from Law Talk with Mike, welcome. Thanks for popping in. I appreciate it. I really do. Make sure you catch the first few minutes when you see the pro se, because he's really good. You can poach anything you want. I send you videos, so you can't poach from me. But the first pro se guy, that was Indiana. All right. And then I think we were just in Colorado. And now I think, is this Texas? Right, guys? No, where's Wanda? She's a normal YouTube judge. I don't play YouTube judge as often, but this This one got me. So normally I have my own judges that aren't on YouTube. I don't play YouTube judges a lot, but every once in a while I will for Wanda, like Judge Kim we got yesterday. Love Judge Kim. Anyway, buckle up. I got to press play. Here we go.
And line 5, we showed it was served, the petition for the divorce, that the basis of this lawsuit was served an officer, Angela Palacio. Well, I checked in the court system. There is no order for substitute service. So that allow somebody else to be served on behalf of my client. But more shocking, my client wasn't even in Oklahoma in June 2025. My client was in Texas. So how can somebody who is in Texas be served in Oklahoma? Number one. Second one, even if he's in Oklahoma, there is no substitute order that allow my client to be served through Angela Palacio. So my client was not served. So if my client wasn't served, the court have no jurisdiction to enter a judgment against
Vincent, what are you doing? Every time you do
can't
that,
hear
like
you.
the last sentence, I couldn't hear you. It's like you're muffling, you're muffling over the microphone or something.
Okay. Can you hear me now?
Yes.
Something is okay.
Yeah, don't touch anything. Just be still.
Sorry, Joey. I was saying, boy, my client was in Texas in June 2025. And they're claiming that he was served in Oklahoma. That's impossible. He cannot be in two places at the same time. But let's pretend for the argument that he was indeed in Oklahoma. If you look on the exhibit number 1, it was served on somebody, Angela Palacio. My client is not Angela Palacio, and there is no order for substitute service that allow my client to be served through Angela Palacio. So it means that the full judgment they obtain is defective. The court have no jurisdiction to enter a judgment against my client. Therefore, I cited, since we have only 15 minutes, I cited the case law in my motion for new trial that does not allow a court to sign a judgment when somebody is not served. So my client wasn't served. So we will ask the court.
We can't hear you.
Oh,
Went
okay.
out.
Can you hear me
The
now?
court cannot not allow someone to be served.
The court cannot allow a judgment to be obtained on somebody that was never served. So we ask the court to set the judgment aside. And
He's saying, which he's wrong, he's saying that his client was never served. He's correct. His client was not served by the process server because his client is always incarcerated. So the process server took the documents to the prison where he lives and gave it to his roommate with the gun and the keys. And the roommate with the gun and the keys took the documents and signed for them. That equals service. The service, they can't walk it to his cell and hand it to him. That's not the way it works when you live at those special, castles with bars.
grant my client a new trial.
Thank
Now,
you.
I'm gonna call my witness.
Excuse me, I would like to make an opening
What-
statement as well.
I didn't hear what you said, Attorney Ndukwe, but it's
He said he
Attorney
was gonna-
Harper time.
Oh, yes, thank you, Your Honor. And I'll try
Go
not
ahead.
to yell. I'm not mad at you.
I'm sorry, I'm
Um,
not yelling it. I'm just emotional. I'm not yelling. I apologize. It's coming out that way.
Your Honor, first of all, I would like to tell the court that the motion for new trial and the first amended motion for new trial are procedurally defective. A motion for new trial based on matters outside of the record must be supported by affidavits or other competent evidence. This one is not. There is no verification. There are no affidavits. There is no testimony. There's just argument. They allege non-service, lack of notice, mistake or accident, pregnancy, and separate property. Every one of those is an extrinsic fact. Without evidence, the court cannot grant relief. Even assuming these facts were true, Your Honor, the court has no evidence before it to consider them. Again, there is no affidavit, there's no verification, and even the movement on the motion for new trial is not present. However, even if he was present, there should have been an affidavit of verification attached to the motion, considering they are claiming several grounds for a motion for new trial that are outside the record. And I'm not going to go into that in any more detail. However, with regards to the service arguments, Your Honor, to challenge service based on facts outside the record, defendant must present evidence. They did not. The return of service is in the record. The motion does not rebut it with competent proof. The return of service itself is prima facie evidence that the service was sufficient. I'm sure I'm not gonna have to go into too much detail about this, but according to Civil Practices and Remedy Code 17.029, the burden is not on Ms. Alvarado to prove the warden's designation unless and until the return is rebutted with competent evidence. And why I'm referring to Civil Practices and Remedies Code 17.029 is that lays out the service of an inmate who's in prison. And so the process server in this case does not require a substitute service. Each warden can designate the person who is going to accept service on behalf of an inmate. And in this case, that was Ms. Palacios, who is listed in the affidavit that is on file with the court. And at this time, I'd like the court to take judicial notice of the court's file and all its pleadings.
Court takes judicial notice of the court's file.
All right. Anyway, but with regards to that, the court does not add requirements that the legislator Dallas County courts and even the Court of Appeals and the Texas Supreme Court rely on if service compliant is in compliance with the statute, due process is satisfied. There is no hand-to-hand receipt is not required for prisoners who are in jail under Civil Practice Remedy Code 7.029. That's why the steps are in there for service on a inmate, which the process was followed in this motion. Again, there's no magic words that have to be added into the return of service that say that there was hand-to-hand service of the document. And so for him to argue that there was no service and that substitute service was required, that is simply not true. And there is no family code statute that makes that requirement more stringent as well. In Hawley versus State, service on an inmate is valid when citation is delivered to the person designated by the officer in charge of the correctional facility as authorized by Texas Civil Procedure and Remedies Code 17.029. Personal hand-to-hand service on an inmate is not required. Again, that's Hall versus State, 14 Southwest 3D 844. There's another case out there, Henderson versus Department of Public Safety, 879 Southwest 2D 873. Service is effective when made in the manner authorized by statute. Actual receipt by the defendant is not required when statutory service requirements are not met. Opposing counsel is bringing up that there was no order for substitute service. Again, I would point out to the court that there are no affidavits on file making these allegations of defective service, which lack of notice and lack of proper service is something outside of the record and must be verified with an affidavit. With regards to our Exhibit 2, there's a deed that shows the property in question is community property. It lists the parties as husband and wife. So there's that. And again, this other person that he has brought to testify is outside of the record. And so, again, there's no affidavit stating that this person had personal knowledge of the facts that he is trying to allege today. And another thing, one more thing. Exhibit 1 is going to show that my client has incurred almost $9,000 in attorney's fees in executing the divorce and in defending her in this motion for new trial.
Thank you. Attorney Ndukwe, one thing I did notice about your motion is that it did not have an affidavit attached, and pursuant to the Texas Rules of Civil Procedure, I believe number 93, it specifically talks about verified pleadings, and a motion for new trial is a verified pleading, which will require you to have a verification affidavit attached to the motion. What is your response to that? Because I've reviewed the original one you filed as well as the amended one, and it does not have an affidavit attached.
You're going to have to show him where in the book that says that, because he's never heard that before. He's a lawyer.
Georgia, to some degree, you're right. However, on the motion for new trial, if you are testifying something outside what was pled, then you're required to verify it. The law does not say that every motion for new trial must be verified. It's not what it says. It says whatever thing you are contesting that is outside the record of the court, then it has to be verified. If you look on the exhibit we offered here, everything we offer here is part of the record. It's not outside the court record. Example, exhibit number 1. The opposing counsel is trying to mislead the court. He said, yeah, as long as in this citation show that it was served on the designated person, then it will be okay. Okay. Yeah, it's the same testimony we're talking about here. He doesn't have somebody that will testify before this court that Angela Palacio was a designated person to receive this service. She's trying to run away from the substitute order. So this the statute she's quoting is misrepresenting what he said. He said, yes, if it was served on the person that was designated, is he telling this court there is somebody here to testify that Angela Palacio was the person that was designated to receive the petition? The answer is no, unless you will show me. I have looked on people who have logged in. There's none of them. And more importantly, as I told you, if you discount the fact that my client wasn't even in Oklahoma to begin with, because he wasn't verified, but that's where I want the court to zero in. So he wasn't in Oklahoma, he was here in Texas. So if you even discount that, if you go to exhibit that was part of this thing, including their own exhibit, which is exhibit number 2, the property was purchased in 2009. Remember, all we have to show in a motion for new trial is not to prove that everything that we're saying is true, is that we have a meritorious defense. If we are raising a meritorious defense, that this is a separate property, that alone is enough for the court to grant a motion for new trial.
Well, we first have to get there. And I don't believe we can get there without the verification. Do you have any case law that allows me to proceed on a motion for new trial for information, as you stated, that's outside the record, that would allow me to move forward with the motion for new trial with no affidavit attached?
Absolutely. I don't have it here with me, but I can provide with you. I can provide to you. So this is not the file.
We're here today. We're here today.
Yes,
Your
you're
Honor, may
right.
I respond to his argument, please? Just so I have it on the record.
Sure.
Allow me to finish. I'm
Hold
still
on, Attorney Ndukwe.
have-
Attorney Ndukwe. Go ahead, Attorney Harper.
Thank you. Your Honor, again, it's not my client's responsibility to show, again,
Love, shut up. Why are you talking? You have already slam dunk won, and now you're gonna talk. Your client stole 3 houses from this man. Stole 3 houses. He did not sign any of that paperwork, guys. He didn't. He wasn't even in the same state. This attorney can prove that. He just is wrong. He just did it wrong. So this woman has a lost case, and she's won it somehow by the grace of God. He doesn't know what an affidavit is. She didn't verify anything. So she won, and now she's talking. I just want to tell her to shut up. Stop.
let me strike that. The return of citation on its face is enough to establish that the respondent, Mr. Arriaga, the respondent in the divorce was served properly. My client doesn't have a burden after that. He's the one claiming that service was defective. Therefore, the burden shifts to him to argue that, which he's making that oral argument today. However, that doesn't negate the fact that he was required to attach a verified affidavit on his motion. And if you look at his motion for new trial, he doesn't even bring up anywhere in his motion that Mr. Arriaga was not in the state of Oklahoma at the time that he allegedly served. Now, even if he had put that in there, he still did not have any evidence attached to show that service was defective or a verified pleading. So again, my client does not have the burden to prove, because the court has to take the return of citation as valid on its face. So the burden shifts to him, and he has not produced that anywhere. I mean, it probably wouldn't have been that difficult to get something from the warden of the prison to show who was the actual designated person to receive citations on behalf of the jail, and that could have been attached if there was a business records affidavit, or their testimony could have been secured for today's hearing. And so I just wanted to point that out to the court.
Thank
Just
you,
can I
counsel.
respond?
Sure.
Okay. I also asked the court to take a judicial notice of the final decree of divorce, which is exhibit number 3. If you look on that exhibit number 3 alone, there are 4 properties involved. She was awarded the entire 4 property. There's nothing testimony. I have the one of the exhibit I attended to the court is exhibit number 4, which is transcript. There's nothing in the record that show that she testified that this is fair and just division. If you take her argument that you discount our evidence, exhibit number 2, which is a separate property. If you disregard that, then there's no testimony there that show that if you're not if you agree with them that this is a community property, that our exhibit number 2, which show that is a separate property. If you discount that, there's no testimony on exhibit 4, which is a transcript that show that there was a testimony that this is a fair and right division of the community property, that she should be awarded 100% of the 4 properties. Just pretend that it was a community property, that it wasn't a separate property. There's no testimony on the record, on that transcript, exhibit number 4, which is part of the record she's talking about. Nothing there suggested remotely that it was fair and just for her to be given 100% of the 4 property, which we claim to be separate property. What she claims is community. There's nothing in that testimony. The law requires the court to make a finding that is fair and just in the division of property. There's nothing there. Testimony, I have the transcript. I offer it, which is already been admitted as exhibit number 4. There's nothing there that shows it was fair and just, that she be given 100% of what the property she claimed to be community property. So it is part of what we raise as a meritorious defense. How, as the court, there are too many grounds. If you discount, she was properly served, then the court should consider that that the court awarded her 100% of the 4 property, and there's no supporting testimony. I have the decree and the transcript that show it was fair and just that she be given 100% of the property. So I will ask the court, that's another ground for the court to grant a motion for new trial.
Your Honor, may I respond?
So you don't even have to. So even if your arguments were valid, Attorney Ndukwe, without this pleading being verified, which is required by the law, and I haven't come across any case law that allows me to circumvent the law when it talks about a verification being required, because TRCP 93 actually says that it is a required shall. There is no exception to that. I can't even hear any of the evidence about whether or not it was a just and right division. I can't even get there. So the court denies the motion for new trial.
Okay.
And
Thank you all. Can I put my client? Oh, okay. Can I ask for my client for attorney's fees? Can I call her as a witness?
Yes.
Okay, thank you. I would call Yolanda Alvarado, formerly Arriaga.
Yes, you may proceed.
Judge, I'm going to object for a simple reason. There was no pleading. She didn't find a response to motion for the new trial. Therefore, I'm entitled. Allow me to finish, counsel. I'm entitled to be, according to Rule 21 and 21A of Rule of Civil Procedure, I'm entitled to a fair notice. There's nothing here. He filed no motion. He filed no response that she's going to be asking for attorney's fee. So I'm going to object. What would be the basis for her to even testify on attorney's fee?
May I respond, Your Honor?
Yes.
So my client's not required to file a response to the motion for new trial. The case was over. He's trying to open up the new case. He's trying to open up the case again. Also, we had an exhibit hearing, and he did not object to my exhibit regarding attorney's fees, which is exhibit 1. And so my client, I think, should be able to testify as to the fees incurred.
Judge, exhibit is not a pleading.
I don't have to have a pleading on file.
Exhibit is not a pleading. You have to have a pleading. You cannot ask. You cannot get something you didn't ask. The way you ask something from the court, you have to file a motion or file a response. It's like somebody file a petition, you file a general answer. You cannot be. There's no request you're making. You didn't even file a general answer.
Can you talk without yelling at me? Can you please talk without yelling?
Attorney Ndukwe, I know you said that, you're, I'm taking it as passion, right? But you do not have to yell at any of us.
I apologize. I wasn't yelling. That's not what I meant.
I understand, but yeah, just calm down a little bit.
Okay, Judge, my position
I
on
call
what?
my client?
She found no motion. I'm entitled to be given notice, fair notice that she's gonna be asking for attorney's fee today. There's no motion to put me on notice. There's no response to put me on notice. Just filing, submitting an affidavit. It's not enough. Affidavit doesn't get you there. What get you there is the pleading. Just as you can't have it both ways. You're making an argument.
After David? After David.
Oh, the motion for new trial is defective, therefore you cannot hear it. Now, at the same time, you are trying to testify on attorney's fee when you have no motion. There's nothing to give me a fair notice to prepare myself to defend on your request for attorney's fee. I'm objecting for her testifying on that, Your Honor.
Okay, Attorney Harper, did you file an answer with the request for attorney's fees?
Let me check my.
We couldn't have filed one because
I think I filed a notice of appearance, Your Honor. Let me make sure though. Hold on. I have one more place to check. I'm sorry.
I don't
Okay,
know,
you're
Patrick.
okay.
I don't know.
Now, if in her notice of appearance, she put a request in there for attorney's fees, then the court can proceed with that. But Attorney Nduko, if you're saying it happened, then we already
Your Honor,
know
to be honest
what
with you,
I have to do by law.
Right. To be honest with you, I'm going to not request the attorney's fees because I had anticipated, I didn't know what to expect today. So I had put on my exhibit for attorney's fees in case you granted it, because it is.
Not so fast, attorney. Look at her. She wants those attorney fees. 3 houses are not enough for her. She wants you to go after the attorney fees.
In the normal course for attorney's fees to be granted if a motion for new trial is granted. But since you denied that, I think my client's going to be happy with. I did not file a request for attorney's fees for today, so I will not call my client as a witness. And I will promptly get you an order denying the motion for new trial.
If you could get that to me today, I will sign it.
I sure will. I will get it to you today. Thank you.
Guys, guess who probably does have to pay his lawyer, though? The guy sitting in jail. He's going to have to pay this guy a couple $1,000s for this hearing.
Thank you. Are we excused? Okay.
Thank you,
Yeah,
Judge.
excuse. Have a good day.
Thank
You
you,
too.
Judge.
You're welcome. You're welcome.
Okay, I think this is Michigan, right? It's short. It's real short, and you've probably already seen it, but it's really good.
City of Lansing versus Sean Felicia Chester 21-02264.
Okay, this is Jody Beck, I believe, Your Honor.
A just dismissed your case.
He's trying to get an after David right now, but it's not verified.
Your hat. Yeah, court today. Put the hat back on.
Thank you, Your Honor.
Ma'am, you know you had court today?
Yeah.
Why would you come in here like that?
Let me tell you something. I've been sick. It's a lot going on.
Are you sick now?
I am.
You come in my courtroom sick? You trying to get us all sick?
I ain't want to go to jail.
Jail?
Yeah, 'cause
Ma'am,
if I didn't come, I would have had a warrant,
For
right?
you could have logged in for Zoom. Again, I didn't set this for a final pretrial. I wouldn't have set up driving unlicensed for a final pretrial to appear in person. Unless the city is taking a hard stance. Sometimes the city is the federales and they're like, we're not giving offers. If that was the case, that's different. But I was not here. My understanding is that Judge Ball probably did this.
Yes.
And that the last time I saw her was in September and she was working with financial empowerment.
I actually think it was Flores who did this.
Well, it could have been, it is Flores. Flores did do this.
Well, Ms. Chester has made the proper progress, Your Honor, and has obtained her license.
You could appear via Zoom.
I know. She said in person, so I just.
It was a final I get it. Well, realistically, if you made, I mean, these are city ordinance matters. This is on a citation. You've made the progress. There's no reason why your attorney, if your attorney was advised of this before today, could have let the city know and they could have just said, we're gonna dismiss it. Or whatever they were gonna do. I don't know what the offer is.
No. Given the age of the case, it would be amending to an impeding civil infraction.
It's an impeding civil infraction, which I don't, is she able to afford that? Because we have to go through a financial empowerment to get her a license. Are you working? How do you support yourself?
My mom really supports me, honestly.
How old are you?
29.
Dang.
Not everybody got good parents, but I do. So
That's not, but not everybody have good kids. You're not a good kid. If
I am
you're
a good
29 and your mom has to support you.
Yeah.
So you won't get, you don't get a job?
I mean, there's reasons why I can't go to work. You can't just judge somebody off of what you think you know.
No, I looked at, all I did was look at you and your response was not everybody got good parents, but I do. I have a circumstance that prevents me from the ability to work. What circumstance prevents you from the ability to earn a living for yourself at 29?
Spoiled,
Because I don't
entitlement.
have the financial to pay for daycare. Daycare is an arm and a leg.
That's your circumstance.
Yeah, it is.
The fine is $135. When are you going to pay it?
Okay. I could pay it sometime this week. Hopefully that'll be the end of this case.
Her mom can pay it this week, Judge.
I don't think she'll pay the fine within 7 days. You can pay online, or you can come up and pay in person. If you need an extension, it's your responsibility to contact the court to request an extension, okay?
I don't need one.
Oh, that's great. I'm glad you don't, because you don't want to get a show cause and or a bench warrant. Any additional matters for this record?
No, Your Honor. Nothing further, Your Honor.
You're all set.
Okay, we're going to end today with a different judge. And I have a compilation of little cases that step up to the end case, which is the best. So this one right here is Reno. Okay, we see Shelley and Hazlitt. And what's the other one's name? The Regal judge. We see the Regal judge. But this is a different judge that I saw. Not used to.
The court wanted to impose like
She's
a
really
no
good.
physical contact, only telephone or electronic contact with the victim. My client would be willing to do that as well. We were able to speak with his mother. Yes, we were able to speak with his mother. She confirmed that he's been employed doing HVAC for the same company for about 8 years. They seem to hold his job for him even when he's, in custody. They say that he's, a valuable employee. So even when he's been incarcerated, they hold his job and allow him to come back. She also confirmed his phone number. He has ties to the community. His dad and mom live in Fallon. He's had his address for about 3 years. So he seems to be stable. I understand that he's got some drug or substance abuse problems that may lead to this type of behavior. But again, he's willing to submit to drug and alcohol testing. And given his history with compliance, I think that the court can rely on him to do what he needs to do. So we're asking for an own recognizance release with any conditions that the court finds to be appropriate to mitigate any risk to the community.
Ms. Karina Smith, is there anything you would like to say about bail or conditions? You do not have to say anything if you don't want to, but I'd be happy to hear from you. Okay. Hi, can you hear me? Thank you. Nate and I met in AA. He is wonderful. He was sober. When the mental health started to decline is when the substance abuse and the falling off the wagon happened. He was not physically violent with me. When I texted my dad to call him, I said mental breakdown. I wanted someone to take him to Reno Behavioral Health. He needs help in that sense. He has not been physically violent with me. We have a baby on the way in 3 months. I want him to be there. He's a good father. He needs just mental health help. He won't ask for help. He needs help with mental health and the substance abuse. That's it. He once he gets that, I know how he works his program. He works a great program, but mental health as well. And there's programs like Reno Behavioral Health or something like that that I think would really work for him. He just had to sign a court card before. He needs real help, and he won't ask for help. And that's what we were doing.
Thank you, Ms. Smith. So he has received help before. I hear he went through a specialty court program previously. That's intensive help. The problem is this repeatedly happens over and over again, whether he gets help or not. And I think it was purely luck that there wasn't any actual violence to a person, although blood was flicked all over, and there was blood all over the house, a door ripped off his hinges and broken in half, numerous defects to the walls. And given his violent history involving weapons, involving other individuals, there's an absolute danger. This is absolutely a pattern, and it is not going to stop until and unless, I don't know what it's going to take. Because if and when Mr. Smith relapses, which has happened before and may happen again, he's absolutely violent. So I think the $15,000 bond will only is appropriate. And he's going to be supervised by pretrial services. If he posts, he'll be tested for drugs and alcohol. I will allow contact with Ms. Smith by phone or email or text, but no in-person contact. I am not willing to risk what may happen if something like this takes place again. So I will allow there to be contact by phone or remotely, but no in-person contact with Ms. Smith.
Even when I had the baby?
So this is just while the case is pending. The case is at the very early stages. It can be addressed in the future. He'll likely be charged with the criminal complaint in just a couple days. Thank you.
We called for mental health help.
I understand, ma'am. You have to understand his criminal history. And I believe there's an absolute threat to the community. I'm so sorry. I know you don't agree with me, but that's the order I've made. I'm sorry. The next hearing, Ms. Lopez, who would you like to call for the no jail complaints?
Before we move on to the next hearing, if you guys are used to Reno, you're used to leniency. I mean, they're not as lenient as Washington or Colorado, but they're not strict. They're just not a strict type of state. So this judge right here is like a breath of fresh air in Reno right now. She doesn't take no shit from nobody.
Mr. Fontaine?
All right, Joseph Fontaine.
Oh, Julie, with you?
Yes, good morning, Judge.
Good morning. Give me just a moment to make a note on the last matter, counsel.
Yes, ma'am.
So Mr. Fontaine has an arraignment on a criminal matter that ends in 748, and then he also has a citation. And the criminal matter is a no jail complaint. Mr. Fontaine, have you had a chance to review that? And is your name correct and spelled right on that document?
Yes, ma'am. Everything's correct.
Okay. Did you read it? Did you understand the accusation against you?
Yes, ma'am.
All right. Did you watch the video this morning that explains what constitutional rights you give up if you plead guilty or no contest to a misdemeanor?
I didn't watch it this morning, but I watched it. I've seen it.
Okay. And when you previously...
We also had the opportunity to discuss his rights and his case. I don't think the video was played this morning.
That's fine, but I just saw him earlier last week and he indicates he's watched it. So that's sufficient for me. Did you understand those rights, sir?
I did.
All right. Knowing you give them up if you plead guilty or no contest, you can also plead not guilty. How would you like to plead to use or possession of drug paraphernalia, a misdemeanor?
I plead no contest.
I'll accept that. I see you spent at least 2 days in jail. I'll give you 2 days time served. So the case that ends in 748 will be closed. And then I want to turn to your citation. That
I just hope when he leaves, she says, "See you next week."
We had discussed it a little bit the other day. It's a trespassing and a use or possession of drug paraphernalia citation.
Yes, ma'am.
You give up the same constitutional rights if you plead guilty or no contest to the citation. Do you understand that?
Yes, ma'am.
All right. How would you like to plead to count one of the citation, trespassing, not amounting to burglary?
I plead no contest.
And how would you like to plead to use or possession of drug paraphernalia?
No contest.
All right. I will accept that. Again, it looks like you've spent at least a day in custody on this citation. I will give you 1 day concurrent for both counts with 1 day time served. So the citation that ends in 517 will be closed. Mr. Fontaine, I urge you to seek help. You obviously have a problem. So please, there are resources out there. You don't have the court doesn't have to force you to do it. Please seek help on your own, or else you're just going to be back here again
next week.
Thank you so much.
All right. Thank you.
Good luck, Mr. Fontaine.
All right. Who is the other no jail complaint, Ms. Lopez?
Mr. Washington, Samaj or Summer Washington.
Summer Washington.
Hello.
Good morning. Oh, I see. Samaj Washington. Okay. There are 2 Washingtons on this morning.
That's right. There are.
So, Mr. Washington, you should have a no jail complaint there with you. Is your name correct and spelled right on that document?
Yes, ma'am.
Did you read it? Did you understand the accusations against you?
Yes, ma'am.
Okay. Did you either speak with Ms. Lopez this morning about your constitutional rights that you give up, or did you previously watch the video that explains them?
Yes, ma'am.
Okay. So knowing that you give those up if you plead guilty or no contest, you can also plead not guilty. How would you like to plead to use or possession of drug paraphernalia, a misdemeanor?
I plead no contest.
Okay, I will accept that. I see you spent at least 2 days in jail. I'll give you 2 days time served. So the case that ends in 750 will be closed.
Consider setting that a little lower, maybe at $10,000 bondable. With all the same conditions, we don't object to any of the conditions that the state thinks is appropriate.
Thank you. It is highly dangerous to have a group of young men drinking and driving around in cars late at night with numerous guns who then evade law enforcement. And he was already under supervision, so he was aware that he needed to avoid exactly this type of activity. And I'm very concerned he poses a high risk. I think $50,000 bondable is appropriate. He will be supervised by patrol services, no weapons, and tested for drugs and alcohol if he posts a bond.
Morning.
Good morning. So probable cause was found. Mr. Black, I can't approve the public defender. You indicated you have $25,000 in savings. Is that accurate?
Yes.
Okay. So allow the public defender to represent you at the bail hearing, but given that amount in savings, you're going to have to hire your own attorney.
Okay.
But let's proceed with the bail hearing today. Let's start with the state.
Thank you, Your Honor. So based on the information that I have, this will likely be charged as a Category E felony. I don't think any of those other felony charges are going to be filed. So he scores a 5 on the risk assessment. The concern for the state is that he's from Georgia. He reported being in Reno for 1 day. But looking at his criminal history, he's got a misdemeanor arrest for hit and run out of Georgia in 2024. The disposition on that case says bind over. Prior to that, he does have a felony conviction for trafficking marijuana back in 2010 out of, I think, South Carolina, but looks like he was pardoned in 2021 on that. He's got a couple of other possession of marijuana convictions, misdemeanor convictions, one in 2007 out of Texas and one in 2002 out of South Carolina. But based on what the state is likely going to charge in this case, as I mentioned, it's a Category E felony. I'm not objecting to an unrecognizance release, check-ins with pretrial services supervision and testing for controlled substances. I would just, for his edification, I would just let him know that if he doesn't show up, the state will extradite him back. So it would behoove him to show up and take care of this case. With that, I'll submit, Your Honor.
Absolutely.
Thank you. So Mr. Black, I'm going to release you. You're going to be released. Let me make it very clear. This case is not over with. And if you do not show up at these next hearings, we will issue a warrant of arrest, and it sounds like the state will be willing to extradite you from wherever you may be found. So make sure you handle these matters.
Definitely.
Your next court date, which I'll allow you to appear by Zoom if you're no longer in the Reno area, will be January 15th at 9 a.m.
January.
So, sir, let me just confirm your email address with you. Is it mr.black? Okay. That is where, again, I'm approving a Zoom appearance for your arraignment, but you need to make sure you know how to sign on, that you get an email from the court in advance and all of those things, or else you're welcome to be here in person. But if you don't show up by Zoom or in person, then a warrant will issue. Do you understand that?
Yes, ma'am.
Okay, so make sure you do that, appear, and you're going to need to hire your own attorney. We can certainly conduct an arraignment without an attorney. That's just making sure that you know what your charges are, but you're going to have to hire counsel very soon after that.
Okay. Okay.
All right, thank you. That ends this hearing.
Thank you.
Good luck.
Thank you.
Good morning. Probable cause has been found. The public defender is appointed. Let's begin the bail hearing with the state.
I apologize, Your Honor. I thought he was removed from the list, so I didn't prepare him. But if I can just have a quick minute to just take a look at it, I do apologize. I don't know why.
Of course, no problem.
No, sanctions.
Okay, so Your Honor, I see
Put her in jail.
that he was booked on reckless driving and driving on a revoked. I'm looking at his risk assessment now. He scores an 11 on the risk assessment. He reported being in the Reno area since his release from prison in April of 2025. As far as criminal history, I'm going to see if I can make this quicker. I do apologize, Your Honor.
That's all right. And if we need to trail it and wait a few moments, then I'm happy to do that too.
So I'm looking, it looks like he's got so yeah, the biggest problem for him, he's got a felony conviction for hit and run involving death or personal injury. That was in 2023. He was sent to prison in that case 2 to 5 years. And then prior to that, it looks like he's got some additional criminal history. He's got a misdemeanor possession of drug paraphernalia in 2020, a felony conviction for burglary and grand larceny in 2018. Some additional misdemeanors, 2017, 2016, felony conviction in 2014 for attempted grand larceny. So given this case is a reckless driving case, Your Honor, and it looks like he just got out of prison earlier in 2025 for a hit and run causing death or personal injury. The state does believe that bail is appropriate based on risk of safety to the community. It looks like in that case, he was going 60 miles an hour on Virginia Street. He crashed into another vehicle causing injury to the other driver, and then he tried to flee on foot. So I think he's also a risk of future non-appearance. So on this case, Your Honor, the state would request bail in the amount of $5,000 with pretrial services supervision if he's able to post. And that will be all. Thank you.
For the defense.
Your Honor, we're going to request that the court consider releasing him on his own recognizance with conditions. I think that a no driving clause is appropriate, considering his criminal history and the charges in this case. You know, he was released from prison in April, but we were not able to confirm a job. I don't know that $5,000 is appropriate considering the likely outcome in these types of cases, where there's typically a fine of $500 plus fees and house arrest or 30 days of jail. So we would ask that the court consider releasing him. If the court wants testing, there's no allegation that he was intoxicated at the time that he was arrested. But if the court wants testing, given his criminal history, I see that he did get arrested in the past for possession of drug paraphernalia. And obviously this was revoked as a result of a DUI. So I think that maybe testing would be appropriate, and that would have him checking in and mitigate the risk of non-appearance.
So Mr. Rodriguez is allegedly the driver of the vehicle that had young men, alcohol, guns, and that frankly fled the police, although I see he's not noted as eluding, but one of the officers was certainly trying to catch up on them on a bicycle and ended up crashing on his bicycle. And hearing that he had...
Wait, the officer was after a car full of boys on a bicycle, and he crashed his bicycle? Okay.
Criminal history regarding driving and hurting another individual, and he scores highly on the risk assessment. That was why I kept him on for the hearing today. I think that there is an absolute danger to the community. And Ms. Lopez, you may be absolutely correct in how it's handled, but I don't know. I don't know what further investigation will show. So I think bail at $5,000 is appropriate. That's bondable or 10% cash. If he posts, he needs to check in with Reno Justice Court by 5 p.m. the next business day, and we will track his case from there since they're misdemeanors.
No PR for him? What?
Next, we have a first appearance for Kevin Washington.
Your Honor, my client waived his appearance today. This is an ad book. He's in custody already on a fugitive hold, and he's in custody on a case that he got arrested on a couple of days ago. So he's authorized me to make arguments in his absence.
All right, let's start with the state.
Thank you, Your Honor. So yes, Mr. Washington is in custody on a domestic battery by strangulation. That case is pending out of this court. His bail was set at $30,000, bondable only. I think it's probably likely that these charges will be joined up with that case. So as Your Honor read in the PC sheet, he made a number of statements trying to dissuade the victim witness from appearing at court, tried to encourage her to go file an affidavit with a bail bondsman, essentially recanting everything. He has a horrible criminal history. I know some of it was outlined in the probable cause declaration, 2025 cases out of California involving domestic violence, numerous cases. And actually, I believe he had a felony conviction as well. But in any event, Your Honor, he has a horrible criminal history, multiple felonies going back to 2007, most of which are related to violence, some of which are related to domestic violence. So the state is requesting additional bail on these charges in the amount of $10,000 with the conditions previously imposed on the original case, those being pretrial services supervision, no firearms or weapons, and no contact with the victim.
For the defense.
Your Honor, if he had been able to post bail, he would have already. Adding any additional bail here is going to be superfluous. Additionally, if the state believes that these charges are going to be wrapped up in the other ones, I don't know that an additional bail is necessary or appropriate. Reading the PC sheet and looking at the phone calls, it sounds like his partner had already talked to the DA's office and had already made the decision to tell the DA's office that she didn't want to cooperate. So I don't know how much, I really don't know how much dissuading really occurred. But I don't know that adding additional bail to this, if he had been able to post bail, he would have by now. It's already set at $30,000 bondable for the domestic. And, he hasn't been able to post it despite the fact that he's obviously been making phone calls. So I would ask that the court leave it as is, leave him on the $30,000. He's got a fugitive hold out of California anyway. So he's going to have to handle his local charges first and then go see what California is going to do. He's on parole there, so he's at risk of being revoked on that as well.
The documentation of these calls, and a couple were before his bail hearing where Judge Birchie indicated he cannot contact Ms. Valdivia, but there was numerous statements afterwards. Ms. Valdivia describes how badly her throat is hurting because of what he did, how she can't even touch it. She describes the horror her child felt when watching the domestic violence taking place. So I don't think it's a situation where absolutely nothing happened and Mr. Washington is urging her to tell the truth. I think it's exactly the opposite. And he is trying to persuade her, despite saying how afraid she says the family was, despite the bruises she described were all over her. So I think that Mr. Washington even makes mention that he refused his bail hearing. I don't know if he thinks that by evading these hearings, he's not held responsible, but he absolutely is. So I'm sure his public defender told him before, but he needs to be told again. All these calls can and will be used against him. I think an additional $10,000 is appropriate. It's bondable or 10% cash. No contact with Valdivia. That's been in effect. It's also effective immediately today. And all his other conditions relating to his previous case still apply. Next, we have a first appearance and revocation matter for Larry Wofford.
I think this is the guy, guys.
Yep.
Nope. We have one more guy and then the good one. This guy was tweaking the whole time. Hope he's okay.
morning.
Morning.
On Mr. Wofford's first appearance, probable cause has been found, public defenders appointed, and we're also here on the revocation hearing, which is the misdemeanor. So let's begin both matters with the state.
Thank you, Your Honor. The state's requesting $1,000 bail on each case with supervision and testing for controlled substances if he's able to post. So he has that misdemeanor arrest from November 18th. Just a little over a month and a half ago, it looks like. At the time, the state didn't object to an own recognizance release. At that time, despite he does have some prior criminal history, he's got felony convictions in 2022, 2014, and 2011 for grand larceny of a motor vehicle, attempted carjacking, and attempted robbery. He also has a couple of controlled substances related convictions, misdemeanor conviction for PCS and a misdemeanor conviction for being under the influence of controlled substance. Both of those were out of California back in 2010. So it appears he's got a very lengthy history of controlled substances use. He did admit in this case that he had used meth a week prior and marijuana 3 days prior. So unfortunately, he is a high risk of continued criminal conduct. There is a risk to the community there. So the state is requesting $1,000 on each case and supervision with testing for controlled substances.
For the defense.
Your Honor, in the previous case, the case ending in 427, that is the kind of illegal reentry trespassing sort of case, my client was released on his own recognizance and he has appeared at every court hearing. He went to his arraignment. He's got a status conference set for, I think, Monday. In this case, it sounds like he lost his job in August and then he got arrested in November when he re-entered that apartment, allegedly. Ever since then, he's been staying at the CARES campus. We talked to his wife. It sounds like they might be separating, but nevertheless, she seems to indicate that they're waiting a voucher through the Reno Housing Authority. So hopefully he's going to be getting housing soon. Obviously, that can't happen if he remains in custody. These types of offenses,
if you're in custody, technically you have housing,
are less likely to occur if he's, appropriately housed. He has been showing up and doing the things that he needs to do for court. I believe that if he were to be placed on testing and conditions, his past performance is an indicator of future performance. He's going to come to court. He's going to do what he needs to do. I think, we're just really concerned about him having that voucher and losing his spot with the Reno Housing Authority. It's really difficult to get on that list. It's really difficult to get off that list, especially now that we're entering the colder months. So we're asking the court to give him another opportunity. He's willing to do whatever conditions, including no driving and testing, checking in as often as the court wants him to. And we can make his arraignment on Monday at the same time as the status conference for the other hearing. Or we can set it another day. He says that he'll come to court whenever the court wants him to.
On the previous misdemeanor that involves the unlawful staying or illegal entry, I'm not going to hold him on that. I'm going to keep his own recognizance release in place. But on the new driving under the influence allegation, I'm concerned. He's admitting to using methamphetamine. He crashed his vehicle. Luckily, his car was the only one that was involved and he didn't hurt anybody else, but that there was a crash. And he also scores, he was overridden, but he scored a 7, which is not low, and his record is pretty severe.
It's low. The last guy had an 11. 11.
So
out of
I
10.
think the monetary bail is appropriate on the DUI allegation. I'll set it at $1,000. That's bondable or 10% cash. I think that's kind of generous given the totality of the circumstances. And if he posts that, he's to report to Reno Justice Court by 5 p.m. the next business day, and the DUI rant will be completed. Thank you. And we'll keep his other case in place for the mandatory status conference on the 5th.
She set you a bail on the DUI only, so she released you on the other one.
Okay, but
he's not
And
done.
Judge, I'm gonna change his MSC to 9 a.m. Since he'll be in custody for now.
Yep, that's fine. All right, counsel, I believe that was all for this morning, Ms. Phelps.
It's not all. There's another case. Hold on.
No, Your Honor, thank you.
All right, thank you. I'll wait and ask Ms. Lopez.
It is all. It is all. This
Yeah,
is the
so I
last
told the
one.
court that, but she made a decision.
Get that, but.
Okay,
if
Mr. Woodward.
if you know, I'll take anything, I'll go back, he's gonna go up and
Your Honor, Mr. Wofford would ask if the court would additionally consider inpatient transport.
So I'll consider a direct transport to inpatient treatment, but it's got to be direct. There's no getting out beforehand unless he posts a bail.
No, I mean, can I speak?
Sir, I'm not changing my mind again. I've already listened to everything. I have big concerns. So consider it a gift that I set the bail as low as I did and that I'm allowing a direct transport. Don't make me rethink it because you crashed your car and you told the police you had used meth and something else a week prior. So no, this is the absolute best I'm going to do.
Walford, this way, please. What up, regard?
Ms. Lopez, any questions on anybody else?
My God. I was fine until you asked me that.
Look, she laughs.
No additional questions. Thank you so much.
And thank you, Ms. Lopez. I really appreciate your willingness to handle those no jail complaints on the weekend. I really appreciate it. We had some other cases over the weekend that the public defender wasn't willing to do, and I wasn't quite sure why. So I appreciate your willingness. Thank you.
Probably
Thank you,
because
Erin.
of the snow.
Happy New Year.
Have a good day.
Not really. They're in Arizona. There was no snow. All right, guys, that's it. Thank you so much for the raid. I appreciate it. Thank you, everybody, for coming out. I do have more of her tomorrow where she really lays into this guy. It's a jail call, though, so it's not in this courtroom. It's a little different. I also have a new judge tomorrow. When I say tomorrow, I mean in like 7 hours. But no, I appreciate everybody for coming out tonight. I really do. And I hope you guys have a great night. And behave, okay? I don't want to see you on my YouTube. But I will show you if you're there. Bye, guys. Thank you.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At court vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain. 'Cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide.